Hello, I'm Polly, and today I've chosen to speak about equity and trust law. Now, there is no denying that this is a hard module. I found it hard, other people found it hard. But I was hoping, let's try and break this down in a simple manner and see if we can help other people. Now, as you can see from the screen, I'm going to be talking about the three certainties. This is probably a topic you would learn in your second lecture, and hopefully previously you would have learned about the history of equity and trust, what equity is and what trust is, and maybe the types of trust, so fixed, discretionary, and things like that. So we're going to jump straight in with three certainties. And the key thing to remember is that all trusts must satisfy the three certainties. My authority for this comes from Knight and Knight of 1840. So for an express trust to be valid and enforceable, the three certainties must be complied with. Now, the three certainties are as follows: the certainty of intention, so is the trust intended at all? The certainty of subject matter, what property is to be subject to the trust, and the certainty of object, so who are the beneficiaries of the trust. Now, we won't have time to go through all three of them. My lecture on this was 2 hours, but let's go through as much of certainty of intention as possible and the practical application of this within your exam. So, certainty of intention. The key things to remember here are precatory words and imperative words. On one hand, we have the precatory words. These just intend to create a gift, not a trust. It's just a hope, it's just a wish, it's just a mere moral obligation. On the other hand, an imperative word says it in the name, a command word. It's a word that gives you a duty to do something, and it's legally enforceable, and it will be legally enforceable in the courts rather than simply a mere moral obligation. So I'm going to have a look at the key cases here, which can be distinguished on the basis that they have precatory words. And as I said earlier, this is only enough to satisfy the gift. These don't satisfy the certainty of intention, and therefore the trust will fail. So we have Lamb and aims to be at her disposal in any way she may think best for the benefit of herself and her family. We have re Adams and Kensington Vestry, which is in full confidence that she would do what is right. And we have re Diggles, it is my desire that my daughter allows Anne an annuity of £25 during her life. Now, as we can see from these words here, we have desire to do what is right, to be at her disposal in any way she may think best. These are all just merely precatory words. There's no legally enforceability in them. They're not giving us the certainty of intention that we need in order to create this trust. So if you're given a provision with this type of word, have a look at that language and construe that on that basis, it's not enough to establish your certainty of intention. But there is always a but in the law. So the context may tell you otherwise. There may be an existence of precatory words, but the context allows this for the certainty of intention to be satisfied. So the importance of context. The key cases here, well, the key case is Comiskey and Bowring-Hanbury, which says, in full confidence that she would devise it to one or more of my nieces as they may think fit. So immediately you think, well, this is similar to the other ones. This is using precatory language. However, the House of Lords sat down and looked at the context within the case. The uncle had taken the moral obligation to be responsible for the nieces throughout their lifetimes, and therefore he did intend to impose a trust obligation on his wife when he died. So those are the two sort of contrasting cases there. And you're going to look at this in a practical application and decide what one you think fits best. Now I'm going to go over the application here with two provisions from a formative question of mine. So we're going to start with just noting down the IRAC structure, which you've probably been told to use in problem questions. So this is the issue, the relevant authority, the application or analysis, and the conclusion. So this provision you're met with, you sit down in an exam. It says £1 million to my husband Michael to use as he deems fit, but it is my hope and confidence that he will use the money to provide for the maintenance of my beloved young nephew Patrick. Now the issue is, as we're establishing, is certainty of intention present? Now you need to move to a relevant authority. The relevant authority in terms of satisfying the certainty of intention will be those cases on this slide. So Lamb and Ames, Adams and Kensington Vestry, and Diggles. Now, you can say that these are this provision is materially very similar to those cases that we have already discussed, and therefore is an indication already that the trust will possibly fail. Now, let's analyse this. So, here we have hope and confidence, and these are precatory words, which means that it's not enough to establish that certainty of intention. And you're going to analyse those words. You can say the language used by so-and-so in their provision is the reason the trust fails, because it wasn't enough to establish that certainty of intention. And that's when you put in your conclusion, overall, the certainty of intention is not established, and therefore the trust will fail. Now, in contrast, we're going to have a look at another case. So again, the importance of IRAC. So the issue is the same as last time, and the relevant authority here is the same, essentially the same provision, but we've added on whom I cared for financially and supported during my life, treating him as my own son. Now, the relevant authority that this draws connotations to and reminds you of is Comiskey and Bowring-Hanbury. It's important, I like to note in my essays that I haven't sat down as the House of Lords did with the full relationship throughout the lifetime of the uncle and the niece in order to make that fully informed decision. I haven't had that. All I've got is this provision to work with. But to me, I'm satisfied in my analysis that I've got the context there in order to see that the husband and the wife or husband, they did care for the nephew Patrick and financially support him as well, and treated him as their own son. And this is enough to show that there is the context. You can look through the precatory language there and see that they intended for this to be a trust, and therefore it was an obligation to do something. And in that way, I would like to conclude for that provision that the certainty of intention is satisfied and this is a valid trust. So those are just two things that may come up in your exam, two provisions that can be interpreted in different ways. There is a little bit more to certainty of intention, but not too much more. But those are the basis of it. Always remember to look at that language, remember the key terms, precatory and imperative, to show to the examiner that you are analysing the provision that's in front of you, and then conclude it. And that will be your mini conclusion for certainty of intention. And after this, you're going to certainty of objects and certainty of subject matter. But thank you for listening.